order the Subdivision Committee special meeting. Yay. Can we have roll call, please?
Chair Cook,
Here.
Vice Chair Andre,
Here.
Committee Member DeBolt is absent. Committee Member Lowe,
Here.
Committee Member Riley is absent. Committee Member Sofocanic.
You forgot me.
Here.
I'm sorry. There you are. I'm sorry. Committee Member Gross.
Here.
Should the record reflect DeBolt as being recusing himself as opposed to being out?
Yes, I was just going to state that Commissioner DeBolt, commissioners on this? Committee member
Oh.
DeBolt had a conflict of interest. The city attorney's office advised him to recuse himself, and so he did, and therefore he left. This was the last item.
Thank you.
Okay, so we'll move on to item A, potential violation of the Subdivision Map Act. Do we have a report?
Thank you, Madam Chair and committee members. Unbeknownst to the commission, you are also the Subdivision Committee. You wear another hat. And Chapter 16.02060 of our municipal code dictates what that is for the purposes of our code, the Planning Commission shall constitute the Subdivision Committee, and you get to serve as that. That the Los Alamitos Subdivision Committee is designated as an advisory agency, and that term is used in Subdivision Map Act and shall have the authority to review, approve, conditionally approve, and disapprove tentative tract maps, tentative parcel maps, and lot line adjustments. The Subdivision Committee shall review and make recommendations to the City Council on petitions for reversion of acreage, and the Subdivision Committee shall perform other such duties as may be specified by the City Council. So, that kind of defines of why you exist. On March 9th, the Development Service Director, myself, was presented with a packet of information from Mr. Art DeBolt stating that Arrowhead property may have been divided in violation of the Subdivision Map Act or City Code. In accordance with the section of the section 66499.36 of the Subdivision Map Act, when a city knows a property has been divided in violation, it must follow certain procedures. And those procedures include putting the owner and ownership on notice, and setting a date for a hearing, and even the timeline of when that hearing should be. So we've gone through that portion. It brings us up to tonight, where now we have put on record our feelings about the Subdivision Map Act violation. We've placed in the staff report Art DeBolt's concerns, concern 1 and concern 2. The attorney representing the property owner is in the audience. So far so good. Everything's working out, and we're here tonight. And so the commission will hear, you've seen the claim of the Subdivision Map Act violation in your staff report. You will hear from their city attorney, their attorney. No offense, Lisa. It's getting late. You'll hear from their attorney. You also have a letter from their attorney. We'll have Roger Grable's name on the top right, and it is dated May 19th, 2016. So I want to make sure each of you have that same letter with you, and for the public's sake, there are copies of that letter on the back wall. With that, we have our city engineer here who deals with subdivisions and map acts and has experience and testimony. And then along his side is his trusty subdivision sidekick, Dave Nell. Dave Nell is with us tonight. He's been an expert witness many times on Subdivision Map Act areas of expertise in the state of California. And he's going to provide more information to the commission tonight as we hold this hearing. It is a hearing, and therefore you would take public testimony. And then we have Dave Nell and Dave Hunt here if you should you have any technical questions about the Subdivision Map Act and this particular violation, or even the interpretation of what is in Attorney Grable's letter and what's in the claim from Mr. DeBolt. So I hope I've wrapped that up. Lisa, I think,
Yeah,
has
and
a
I-
few extra words.
And I just want to say, although we didn't put public comment item on this specific agenda, it is governed by the Brown Act, and
Okay.
therefore public may comment on this as well as the interested parties.
Okay, with that, we'll open it up for public comment.
J.M. Ivler. As some of you know, or may be aware, I was one of the named members of Citizens for a Fair Trash Contract. We successfully sued the city of Los Alamitos for violation of their own city code. When this document was provided by Mr. DeBolt, it had to go to the city. The city had to make a determination if the information in the document was valid, and if it was valid, there were first the MAP Act and the city code. Our city code stated that there was actions that they had to take. The city council, that the city attorney decided that they would not follow our city code, but that the MAP Act would take precedence and they would follow the MAP Act instead of our city code. That's a decision for the city attorney to make, and the city attorney made it. What specifically they had to do was say, it appears that the land here, based upon the information that the city has received, was separated on the horizontal without the approval of the city, in violation of the MAP Act. Now, we have properties that have been divided on the horizontal in the city. For instance, Mr. Gross owns a condominium in a industrial area or a commercial area.
Used to.
Used to own a condominium in a commercial area that was a condominium. It was divided on the horizontal, and that is approved by that was approved by the city, and that's fine. It appears, based upon the documentation that was filed, that this piece of property was divided on the horizontal. The letter that should have gone to the owners, multiple, I believe, there are 4 separate deeds here, should have said that it appears, based upon the deeds, that this piece of property was divided on the horizontal in violation of the MAP Act. Then they would know exactly what the violation is, because the city determined that it appears that this is what happened. And they could come and they could say, here's approval from the city that we didn't violate the MAP Act. You guys approved us dividing this on the horizontal. It's really cut and dried and fairly simple. Except that's not the letter that the city sent to the landowners. Even the landowners admit the city failed to provide adequate notice, failed to, it's a 1-paragraph statement and it doesn't show up in the letter. I fully agree that they weren't properly advised. According to the MAP Act, it's fairly clear how that should have been done, and it wasn't done in a way that let the landowners know exactly what it was that the city has determined is the concern point that has to come before you. Like I said, I've been a plaintiff in cause against my city. At your last meeting, just moments ago, on this piece of property, you said, somebody's not going to be happy here. If this doesn't go back to the city to properly touch each step, clearly state what the city has found, that the property appears to have 4 owners, appears to be divided on the horizontal, and there is no record of the city approving that, which is a violation of the MAP Act. and then sends that letter and gives them the time they need to find whatever document approves the division of this property on the horizontal to present to you, because that's all it takes, is them presenting proof that it has been approved to divide this property on the horizontal. Then one of the two of us, if this continues and doesn't get done right, is going to have cause for our city attorney to go to the city council and ask for a closed session because there's a potential of litigation against the city. My city doesn't have the funds to deal with the potential of litigation this time, because last time when there was the potential of litigation, and there was litigation, the trash people paid for it. This time, it would come out of our budgets, out of our general fund. And I really don't want our general fund money being misspent on litigation. So I'm asking you to please kick this back to the Community Development Director and the city staff to either A, follow our city code, or B, do what the MAP Act says and clearly delineate the information that was provided by Art DeBolt as statements of fact, that it appears to the city of Los Alamitos that the MAP Act has been violated by cutting this property on the horizontal without the proper approvals, and please come in and show us that you have the proper approvals to do this. Please kick this back. Do not hold this meeting. Kick it back, have it done right, and avoid potentially costly litigation of the city of Los Alamitos by either a group of plaintiffs or by the landowner. Thank you very much for your time, and I do hope you'll consider my suggestion to kick this back to be done properly this time.
Thank you.
Madam Chair?
Yes.
Commission, I assume you're still the chairman. I think staff needs, before we hear from the property owner, to put forth a little bit more facts into the record. Normally, it is when there is perceived to be a violation of the Subdivision Map Act, which is fairly rare, it is something that staff has found, staff has determined, and staff affirmatively can say with speaking with the city attorney, yes, we definitively believe that there's a violation here, and we give the other side a chance to present evidence to the contrary. In this case, it wasn't staff who came up with the alleged violations. Mr. DeBolt did bring it to our attention with his letter. While Mr. Ivler says the one paragraph was clear, it wasn't clear to the city attorney, the assistant city attorney, or the community development director that the alleged violation was the improper separation on a horizontal plane. The letter went out as it did because all we understood is what was in Commissioner DeBolt's, or I'm going to say Mr. DeBolt's letter, because it was filed as a private citizen, as not matter member of the commission. Nevertheless, while Mr. Grable raised the issue of improper notice as one of his grounds in his letter, I do believe his letter addressed both the issue of the antiquated map of it being divided before 1891, and also address the horizontal delineation. And we do have, as Mr. Mendoza said, now that we had the response and we had an expert at Wildan who could review this, I think he's prepared to put onto the record tonight too his views of it. So before you take any action, continue going forward and listen to what everybody has to say. And if you feel need to, that you can make a decision with what you have tonight, or you think it needs to go back. I don't believe that we feel it needs to be returned.
Okay, thank you.
So I think that the next step would be, if there's no one else, to have Mr. Grable address the
Okay,
commission.
would you like to come up?
Yes, and I apologize for my voice, hopefully it's clear enough. I am Roger Grable, I represent the landowner in this matter, the subdivision matter. I haven't heard what your staff position is, and I would like to hear from them first before I speak. That's all right.
Okay.
Dave, no? Dave, why don't you start by introducing yourself and some of your experience?
Sure. David Nell, I'm a licensed land surveyor. I've been in the business about 45 years. I deal almost exclusively in the division of land. What we're dealing with tonight is very esoteric. You probably have never even been involved in something like this. It sounds like this is your first subdivision committee hearing, and I'm not surprised. I act as city surveyor in about 18 cities, and I'm actually embroiled in one of these in a city of Hawaiian Gardens right now. So again, I've been doing this for a long time. I go to court, I deal with title attorneys, I deal with judges and lawyers, and this is a situation where I encounter a lot, but you probably have never even encountered before. In reviewing what was sent to me a number of weeks ago by Art DeBolt, I immediately looked at it, and I go, there's nothing out of the ordinary with this. And I conveyed this to Steve Mendoza. And I went back a couple days later, looked at it again. I found nothing afoul of the MAP Act at all. It was very much in keeping what I see on a day-to-day basis. There was nothing that I thought was illegal, out of sorts, a break in the chain of title, wild card deeds in the title. There was nothing out of the ordinary. There's one thing that is somewhat different in it, in that there are 2 assessors parcels, but there are 4 assessors parcel numbers. This is because if you read the deed from like 1982, I believe, there are legal descriptions for 2 parcels, and then there are legal descriptions for the improvements on the 2 parcels. That gives you 4 legal descriptions for assessors parcels. This does not make it in 4 parcels. It makes it 2 parcels, 2 land parcels, and 2 improvement parcels. This is an act of the assessor's office. It is not a function of the Subdivision Map Act. It is not to be confused with a subdivision. I think that's where Mr. DeBolt, I believe, went wrong in his assessment of what went on. He also alleged that this property was subdivided illegally in the 1890s or whatever, and he cited a case called Gardner versus County of Sonoma, which I'm very familiar with. It is not even germane to this issue. It just isn't. It's almost like he pulled it out from a hat and said, this sounds good. I became familiar with Gardner versus Sonoma, which basically deals with certificates of compliance. A number of years ago, San Simeon State Beach, up in that area, had a number of beachfront parcels. They were very small, and a very much entrepreneur went up there, bought these parcels, and sought to get certificates of compliance on them as kind of a hostage situation so that he could get the conservationists to pay a lot more money than they were actually worth just to keep them out of development. And so the case, Gardner versus County of Sonoma, became, to me at least, very recognizable at that time. So last week when I got the letter from Mr. Grable, I read through it, and I concurred with everything he said. I thought he actually got it spot on as far as his assessment of Mr. DeBold's allegations, the interpretation of the 1890 laws, the antiquated lands. They don't apply here. Everything I saw in the deed was the Rancho Los Alamitos, then there was a 1961 cut deed in which the properties were subdivided, and then there was a conveyance forward, and then there was the division into 4 parcels again. The 2 legal parcels, 2 land parcels, and the 2 improvement parcels. Again, we have to understand the assessor's maps are for assessment, taxation purposes only. They do not follow the the regulations of the Subdivision Map Act. And I think there's a lot of confusion out there. You look at an assessor's parcel, and you think, oh, that's a legal parcel. It is not necessarily the case. There are only 2 legal parcels here, but there's 4 assessor's parcels, 2 being for improvements. It's basically what's called a tax lift, in which you can take the improvements away from the land and have them assessed separately. A good example, you have a shopping center with like a McDonald's on it. McDonald's will make a request of the tax assessor to have just the building, their improvements, the outline of the building, have a tax bill just for that sent to their headquarters in Oak Park, Illinois. And I've done this on several occasions. The landowner pays for the land taxes underneath, but the improvements get sent to the corporate headquarters of these various entities. And I think that has led to some confusion here. There is not an illegal subdivision of property here at all. Any questions I can help you with or answer?
Go ahead.
You stated you've been your
Yeah.
title was, for 45 years, you're,
I'm a licensed land surveyor. I actually serve as your city surveyor.
okay. Are you a member of the state bar?
No.
Okay. So your opinions are, as a surveyor with 45 years of experience, I'm sure they're spot on, but, okay, that's my question.
Yeah, I could just say, you're right, I'm not an attorney, but attorneys call me for my opinion.
Okay. You're an expert witness.
I'm an expert witness, correct.
Probably a very good one, too.
I like to think so, yes. Thank you.
Well, obviously, that's helpful. But I will say that as your surveyor, actually, these decisions are within the scope of their responsibilities. They're the ones that have to certify and determine that the maps are valid. So that is part of their function. I think that where we are now is the only evidence from the city side is that there's no violation. We have Mr. DeVille's concerns, but the evidence you have, the only evidence you have, is that there is no violation. So I think at this point, I really have nothing to add. Happy to answer questions, but you have my letter, so you understand my position.
Thank you. Anything else?
I have
Go ahead.
a question for Stan. Question for council.
Yes.
Did your firm read Mr. Grable's response?
Yes.
You talked about evidence, counsel, and I'm looking at the evidence, and we have an expert witness here who's clarified the evidence and probably is factually correct on it. And your response letter is probably been well-researched and shepherdized, and it's probably spot on. My thought is, for the committee, what would be the harm in having, the only letter I see from the city is from Stephen. And just in the abundance of caution and for further protection of staff, what would be the harm of having a letter come from our attorney to Mr. Grable? It's basically stating what the gentleman has said. I mean, I want to take it up a notch. Our attorney to their attorney. What's the harm of that?
That's not standard procedure when somebody submits something to a planning commission or a committee to have a response, even when it's we've never responded, for instance, to any of Ms. Horry's letters on the zoning issue or anything else. That's just not standard procedure. I will state for the record that as Mr. Nell said, this is a very esoteric area of the law. We did do research on this. We tried to figure it out. My initial reaction was that because it was separated by, described by meets and bounds, it probably did not fall within the Gardner case, and it was an exception to that. Nevertheless, we put it forward for the subdivision committee to make the full recommendation. We tried to speak to various title officers ourselves who really couldn't even comprehend why we were asking these questions. And on a pro bono basis, nobody wanted to come here and become involved in this because I don't think money was authorized, was it, Steve, by the council at
A
first?
minor amount was, yeah.
Minor amount. And we, as the city attorney's office, are in concurrence with our city surveyor on this and do not find any fault in Mr. Grable's letters. And
So you say the city attorney's in concurrence with Mr., I'm sorry, sir,
Mr. Nell.
Mr. Nell. So you have had discussions at the city attorney level?
I've had a discussion with Mr. Nell.
Okay. And you know, I mean, I'm just trying, in the abundance of caution, you know, you say it's not standard procedure, but the comment was, this isn't standard procedure because we get the letter, usually don't get the letter from a citizen. So it did change the complexion of this whole thing, and we had to bring in an expert like Mr. Nell, and we got a response from another law firm. And if you as counsel representing your firm feel that we don't need to take it up to have our city respond with a letter, then I understand. I just thought it'd be an abundance of caution. Since we have opposing counsel, we have expert witness
I
to
think
handle what is not a standard procedure.
we don't believe it's necessary. I mean, you now have Mr. Nell's advice, Mr. Grable's letter, and I'm stating I concur with Mr. Nell and therefore also with Mr. Grable on the record. And I think the committee, if they have any more questions, can certainly ask them of anyone. Otherwise, I think you can discuss and make a decision.
I gotta tell you, he's a great expert witness because you explained that in a way that for a novice, I wouldn't have any clue what you were talking about, and you broke it down beautifully. So I understand, and I tend to concur with the Mr. Grable's letter.
Was the recommendation made before or after the information from Mr. Nell?
The recommendation.
The staff recommendation?
Mhm.
Staff
Direct
letter?
staff to record a notice of violation,
Or, it's saying,
It was
it's
made-
either
or
or.
should know by.
Evaluate the evidence and determine if there is a violation, and if so, direct staff to record a notice of violation with the county recorder, or should no violation exist, the city shall mail a clearance letter to the owner.
Got it.
There's no recommendation.
Yeah.
Yeah. Gives you options.
It does.
Leaves it open-ended because a hearing is exactly that, a hearing where no new information could be provided
No, I read
that
it.
wasn't previously provided. And Roger Grable's letter did not come out until after the staff report, or it would have been in your staff report.
Okay. I read it incorrectly anyway. My apologies.
That's fine. It's late.
It is
Yeah.
late.
I can make a
Seems pretty
recommendation
cut and dry to me.
that we, should no violation exist, then direct the city to do the letter to Mr. Grable.
I'll second.
Okay, we have a motion and a second. All those in favor?
Aye.
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 Opposed? Motion carries.
You can adjourn the subdivision committee meeting never to
Okay.
be held again.
Yeah, okay. This meeting's adjourned. Thank you.
Figure out if you're another committee. Is there a third committee that we don't know about?
Nobody told us about this
No
one.
more.